Now, the other thing that can get you into trouble, and this is, we hear this all the time, and managers ring up and try and shift, and isn't this about shifting responsibility? Managers will ring me up and say, is it okay if I? So that then it becomes my problem. I say yes, then I'm in trouble. But they ring up and they say, well, what do I have to put on my owner's corporation certificate? What do I have to put on my owner's corporation? Is it all right, David, if I don't? Well, no, it isn't. It isn't. Recently, we had one where a lot owner had commissioned a report, a maintenance report, on various lots. But the maintenance report also pointed out that there was some common property damage. It wasn't paid for by the owners' corporation. It wasn't officially given to the owners' corporation manager, but nonetheless, he tells me that he has emailed that report to the other lot owners. So there you are. You know, he knew about it, even though it's not his report, and even though probably, well, it does now. The moment he used his email, it forms part of the record of the owners' corporation. So if a purchaser comes along and the owners' corporation manager looks at the certificate, or the purchaser looks at the owners' corporation certificate and makes no mention of the fact that there's significant works to common property that have been identified, and then a year later he gets a special levy, and then finds out that you knew, you'll pay, right? You'll pay, right? I've been at VCAT a number of times where things have been omitted from an owners' corporation certificate. You guys have to pay. So make sure you get that right. Rules. There was a conversation in Carol's things about rules. And we do a lot of these and registry. As we keep on saying, you can register any rule you like. And we'll advise you whether we think that it's enforceable or not. But at the end of the day, if it's not in line with the law, it's unenforceable. And I think we had member Roland just recently say in relation to a dog rule that it was not, you can't have a dog rule because it's prejudicial against dog owners. It singles them out. That was her reasoning in that. So that was an interesting take. Although at the end of that judgment, Roland did say that a better rule prohibiting dogs may get through, but this one was a bit clumsy, so she just disallowed it. Well, if I call it a day of that, it doesn't catch us up in time.
That one's just gone. All right.
That'll do me.
Okay, good morning ladies and gentlemen. My name's Jenny and I'm here from Verity Bay Lawyers. I do see a number of familiar faces in the audience, but I also see a couple of new ones. So very happy to meet you all today. This morning you're going to be seeing me a couple of times, and I thought what I might do is start off by giving you a bit of an idea of how I approach owners corporation law in general. Now I think the seminar that we've got this morning is fantastic. The reason for that is because Strata 101, what's that all about? It's about giving managers an overview of all of the different areas, the topics, the issues that you might be facing. Now, if you're not a manager, you're a supplier in the audience here today, it also helps you to understand the types of issues that managers need to be dealing with and help you to understand why things are done in a particular way. This morning you'll hear from a number of presenters and you'll see that different people approach this area in a different way. You'll hear the experts presenting in a different way. You'll see that people process this information in a different way. They're all fine. It's just what works better for you. The way that I approach this type of matter is as follows. I think when you're looking at, particularly for the newer managers, a new area, something which you might not be familiar with, it's really important to know the rules of the game. If you don't understand the rules of the game, you can't issue spot. You can't identify when something is going to be a problem, and you can't manage it in such a way that reduces risk for you, improves efficiency, and allows you to deal with the situation or to ask for help when you need to. So that's why I think having an overview is really helpful. It is going to be a lot of information for you. I don't want to repeat that, but there's a few ways which I have been able to perhaps help you process that information. So today you'll walk away with 2 documents from our firm, from Berrigan Bay Lawyers. One is a set of slides. I'm going to talk to the slides. I'm not going to stick to the slides. You've got that. You're welcome to go through it in your own time. I will draw your attention to a number of the slides where there are issues and potential for risk. The second slide that you'll have is what I've loosely called the legislation cheat sheet. Okay? Now, legislation is something that we deal with. Why? Because the rules of the game are spelled out for us in legislation. Owners' corporations are created by statute, they're governed by statute. If there's any disputes or any problems that arise, it's the legislation which is going to decide that at the end of the day. Now, my job here isn't to teach you how to necessarily read and interpret legislation. You're not lawyers. I'm a lawyer. I started as a junior lawyer. I'm now a director. I've been in the industry for more than 15 years. I've taught a number of lawyers in my time and a number of managers as well. My job is not to teach you to read legislation the same way that I teach lawyers how to do that. Although sometimes managers do need to read legislation because you need to find the rules, you shouldn't be taking on the responsibility of being a lawyer. Now, what I want to do is to show you how to find things if you need to, including the legislation, but it's the principles, it's the thinking, the logic, the step-by-step process that goes on in your mind that I want you to walk away from my presentation with today. Now, I find in the first 2 or 3 years of being a manager or working in a new area of practice, you're going to be learning a lot of things. This morning, the first section of my presentation is going to be talking about 2 things. One is rules and 2, documentation. Rules and documentation is actually very practical. Rules, what are we talking about with rules? Really, we're going to be talking about here, what rules can you be making for the owner's corporation? What process, how do you go about making those rules? And how do you enforce them? Then finally, what happens when there's a dispute about rules? In relation to documentation, what I'm going to be looking at is what documents does the owner's corporation need to maintain? Then who has access? Who can request to see them or make a copy of the documentation that you as a manager need to hold for the owner's corporation? And finally, I'm going to look at, are there any limitations? Can you restrict access? Can you deal with privacy? All of those types of things. Now, looking at rules, the reason why I say rules and documentation is very practical from a manager perspective is because these 2 issues that I'm dealing with now are so fundamental to your job as a manager. There are certain things which you can say, look, that's outside of the scope of my retainer, or that's outside of the scope of my expertise as a manager. But rules and documentation fall squarely within your responsibility. So, what kind of rules are we talking about? At the first instance, we're talking about specific rules which have been made out for this particular owner's corporation. We used to call them special rules or additional rules. They're the ones which have been tailor-made for a particular owner's corporation. Now, if you set up rules properly for your owner's corporation, not only will that help to regulate what goes on within an organisation, such as the OC, but it actually is a tool for you as the manager to be able to tell people, yes, you can do this, or no, you cannot. Therefore, in rules, you will see positive obligations and negative obligations. Those two words, they're jargon. That's lawyer speak for things that you can do and things that you can't do. Okay? So, how do you go about setting up rules and so forth? I'm going to draw your attention to one particular slide. In the interest of time, the other two slides that I've gone through, you'll see there are 2 points that I'll mark from each of them. In the very first slide, when you're making rules, you have to make them for a proper purpose. So if you're keen on making notes, that's the section on this slide that I think you should be highlighting. It must be for a proper purpose, which is control, management, administration, or use and enjoyment of common property or a lot. That's the subject matter for which your rule must be. If it's outside of that subject matter, it will not be enforceable. Next point. David touched on this a moment ago in his presentation. Discrimination. Unfairly discriminating rules are ones which are also unlikely to be able to be enforced. Now, this slide is the one that I want you to focus most of your attention on with me this morning. What I would like to do is to give you a step guide in your mind to say, if you have been asked by an owner's corporation to set up new rules, you need to have a framework in your own mind about how do you actually go to achieve that. The first thing that you do is you need a special resolution, both from a practical perspective, but also from a very theoretical perspective. Because if you can't get your special resolution, and you know that you require a special resolution to make or amend rules, there's no point talking about it. There's no point entertaining this kind of a request from your owner's corporation or your committee if it's just not feasible to get a special resolution. Okay? After you've gone over the first hurdle of getting your special resolution, the next thing that I'll do is I'll tell you to be able to identify what falls under the responsibility of the manager and what is outside of what you can do. For example, if you've been asked by an owner's corporation to draft rules, it may be that you want to have a go at it yourself, or it may be that you get an expert drafter, such as a lawyer, to help you put together those rules. Okay? Whereas, step 2, once the rules have been prepared, and rules can be quite extensive. I've drafted rules for more than 2 or 3 years to get those special rules correct for an owner's corporation. So it might not necessarily be reasonable for an owner's corporation to require the manager to do that. You're setting up effectively bylaws. Most of the rules that you see in an off-the-plan subdivision where you might have retained it from a developer, they have been drafted by lawyers. You'll see the tone of the language that they use. It's not necessarily something which is within the capability or should be expected of managers to draw. Now, you can have a go at it. I don't have a problem with that. At the end of the day, it comes down to enforceability. And I've seen some managers who are very experienced and drafted brilliant rules, better than some of the junior lawyers that I've seen as well. It comes down to what request the OC has made of you. Now, assuming we've got that draft rules put together, everyone's agreed we've got the right resolution, step 2, that needs to be lodged with the register. Okay? There's a process. I've given you pinpoint references to the Act. I've also given you the cheat sheet, which gives you the specific wording of the Act for you to take away and have a look at. Today, my presentation is about issue spotting, identifying where risks arise, identifying when you need to seek help, whether it's from a more experienced manager or from a lawyer or an expert or whoever it is. You've got the pinpoint references in your slides, you've got the cheat sheet, go away and read it once you know what you need to do. How you go about doing that, it's up to you to find in the material, okay? Now, the registration, the lodgement process, that might be done by you, or if you engage lawyers, it might be done by them, comes down to the secretary. Carol already talked about that process, so I'm not going to talk about it anymore. But the next step, step number 3, does fall within the manager's role, and that is to know when rules take effect. Good housekeeping is able to occur when you've got proper rules which are enforceable and you are actually putting them into action. Too often I see owners' corporations who have rules, but nobody actually refers to them. Rules are only as good as what you enforce. You've got to make use of those tools in order to get the maximum benefit. The key point about this, step number 3, is that rules are effective from the day that they're recorded. Why do I emphasise that? Because I've seen a number of rules in owners' corporations which have not been registered. They are not effective. Okay, so if you go through your OC records and you see that rules have been prepared, they may have even been used in the past, but if they're not registered on title, if they're not registered with Land Titles Victoria, on the plan of subdivision, nobody has notice of them, they're not effective. If you come to seek advice from me about enforcement, the first thing I will do is tell you these rules have not been registered, they're not effective. Once they are effective, then we can go through with enforcement. They are binding on owners' corporations. Complaints may be made. There's a process, needs to be in writing, needs to be in the approved form. And you can take matters to VCAT, but only if you go through this particular process. Now, the next thing that I'm going to focus on is model rules. I'm only going to touch on model rules because model rules, this is actually really easy. We have model rules which are provided to us from the regulations. Owners Corporation regulations say if you don't have any special rules, the model rules apply. They are codified. They're not something that we need to import or to implement. They're just there. You can go about changing how those model rules affect your owners' corporations, but if you don't, or if you fail to register, or for whatever reason the rules that you tried to register don't work, we default back to the model rules. Okay? The model rules are not always helpful for your owners' corporation. Why? Because sometimes we've got 2 lot subdivisions, and sometimes you've got 250 lot subdivisions, and the model rules just don't cover for that unique situation that you're dealing with your OC. So my recommendation is, where possible, especially from the outset, when you get a new building, you want to consider, do a health check and see, can we register some special rules to help, if for no other reason than yourself. Help yourself as the manager to be able to properly manage this OC. If not, then we've got the model rules to fall back on. Okay? Now, the dispute resolution process I'm not going to deal with, you've got a lot of information about that. The OC register, this is something that I would like to spend a little bit of time on. And the reason why I want to do that is because I get a lot of questions about OC records from time to time. Now, in the handouts that I've given you on page 6 and page 7 of my handouts, just give everyone a moment to have a look at that. There are 2 things in there that I address. One is the OC register, and one is the OC records. Jargon, a little bit complicated. 2 different obligations. The Owners Corporation Act requires managers to keep a register and also records. One is a subset of the other. Okay? Now, in plain English, it just means the records is a little bit broader than what the register is. Everything in the records is in the everything in the register is also contained in the records, but not everything in the records is contained in the register. So, if you want to just walk away with one slide to comply with everything, keep the records. The difference, if you are interested in understanding first principles and logic, I like telling people why. If you can understand why and the logic, it makes your job that little bit easier because you understand the purpose for which the Act required this. Now, the difference between the register and the records is this, my understanding and interpretation anyway. The register is like an address book. The register deals with members, it deals with rules, it deals with contracts and insurance and so forth that's been taken out. It's a register of all the people and other parties that the Owners Corporation has a relationship with. Whereas the records are broader, in my view, because it also has to include copies of resolutions, decisions made by the owners' corporation, ballots, voting and so forth, which is what enabled the owners' corporation to do certain things or make certain decisions. It includes correspondence, accounts, statements and all of that type of thing. So, those two types of documents you need to be able to distinguish between and also keep. The reason why I say distinguish is because if an owner asks you, or a lot owner, go back to access, owner, mortgagee, purchaser, representative of any of those types of people are able to access that information. And if they request a copy of the OC register, that information is going to be different than if they request a copy of the records. Okay? Now, once again, I'll emphasise the reason why I'm focusing on these topics is because the register and the records, that is something which I invariably see is the responsibility of the manager. It's very different for you to say, oh look, but so-and-so this, or it's squarely the manager's responsibility. And access as well. That's also something which is a little bit tricky because sometimes people require access to the records and also to the register. And managers come and talk to me and say, look, Jenny, do I need to grant them access? If so, can I charge them a fee? What if somebody has said to me, I don't want people to see my records, what can I do? That's the issue about access. Okay, now, you'll see both for records and also for the register, the type of people who can access are the same. The method of access is also quite similar. Has anyone had problems or these types of issues that I've dealt with just a moment ago with access to information? Is it something that you find regularly in your practice as being an issue? Well, look, with these types of things, it really comes down to a case-by-case basis. And this is where I think you need to be able to, firstly, know that issues exist, and secondly, seek help, because different situations can be dealt with in different ways. Okay? For example, did you know that an owner's corporation or a lot owner could be actually charging a fee for access to documents? There's a prescribed fee and so forth. That's one of the ways that you might be able to manage this process. But in future, in your practice, if you do find that access to documents is something that you've got a tricky situation with, I'd be very happy to talk with you about it based on your specific circumstances, because once I know what the specific circumstances are, which records or register you're looking at, there are actually a few tricks about how to manage that process. Now, I'm going to leave the presentation here, having dealt with these two issues, but shortly you'll be hearing back from me about decision making and the types of considerations that you need to consider when making decisions. So I'm going to hand the microphone and the stage back to David.
Thanks, Jenny. Yeah, we're just going to ask Anthony to come up and just swap us.
Excuse me, but I've just got to skip through some slides here. Thank you everyone for having me here. I'm here for a brief period. I've got to get back to another function, so sorry I've probably come in at the wrong moment. Thank you, Shannon, for fitting in. Look, this is the insurance proportion of the Strata 101. It's not meant to be too arduous. It's just, you know, I talk about insurance, we could bore you to death. So the whole idea is really just to fit it into a 30-minute special, which, you know, give you some ideas of how it relates to the Strata industry, and an overview of some key areas that I'm concerned about and some takeaway points. We should have about 25 minutes to go through it, probably about 5 minutes of question time. We'll talk about, it works, we'll talk about the role of an underwriter, what an underwriter is, the different types of classes of insurance. We'll also talk about intermediaries. We will talk about the minimum requirements as far as insurance is concerned with the Strata industry. We will also talk about some suggested areas and some things that you probably should, you know, as take-home points, areas that as I said before, some areas I'm concerned about. We'll talk about some legislation, very briefly, and how that ties in, and we'll finish off with some claims information and some golden rules as far as that's concerned. An underwriter, basically the underwriter is the insurance company. They provide security for insurable losses. An underwriter's role is pretty simple. They provide protection to the insured party against damage to assets and liability protection concerning a person's acts. They do this via insurance policies and products that are designed to cover the risks associated with property liability and casualty insurance. Much the same as cars on the road, Ferraris right through to Fords, there's best practice policies right through to no frills options. Whether it is a best practice policy or a no frills version of a policy or company, the role is pretty similar across the board. Their role is to assess the risks involved in the property they are quoting, which will entail collating information about the policy that they're quoting on. Some of the types of information in particular relating to Strata would be the knowledge of where the address is, the construction materials that are used in the property, the types of occupancies within the property, so whether it's residential or whether it's mixed commercial or commercial, a knowledge of previous claims, and various other sorts of things, you know, such as number of lots within a Strata scheme. In assessing this information, they then price the cover appropriately and provide you with terms. In some cases, if the risk is adverse and it's had some issues in the past, they may decide to apply some excess or impose some sort of sanctions on the policy. From time to time, underwriters will also be asked to interpret their policy wordings, and they'll also be asked to extend policies by way of an endorsement, and might be increased sum insured or no interested parties as such. After all is said and done, the most important role of an underwriter is the claims process. And it doesn't matter whether the price was cheap or whether it was an expensive policy. At the end of the day, the only thing that actually matters is whether or not an insurable loss is actually fixed. That is the purpose of all insurance products, and if you're involved with your clients in the claims process, you'll no doubt find that out in a very short period of time. At the bottom of the slide, just to confuse everyone, I've just shown some insurance companies that you may be familiar with, Vero Cubes, QB, sorry, that's acronym for us in the insurance industry, and some insurance underwriters who you would mainly probably deal with, the likes of CH, Longitude, SUU, SCI, to name a few. Look, unless you know everything about insurance and you can provide your OC clients with multiple options as far as, and assist them with claims, so multiple options on types of covers and premiums and so forth, and the claims process, I honestly think that you should actually consider using an intermediary or a broker. The reason for this is that the broker has a greater market access and they understand the differences between the products that are out there in the market. Their role is to provide you with the best options available in the market and to provide you with expert advice on the different covers available. A good broker will also identify risks associated with your owner's corporation and suggest the best products to go with those risks. And look, regardless of what they say in the marketplace, there are a lot of products that are very similar, but there are a lot of hidden areas that are completely different. So that's why a broker is important. In addition to this, probably most importantly, they can assist you with the claims process. As they understand the claims process, they understand the different types of losses that can occur, and they have an in-depth knowledge of the insurance cover and the insurers as such. They can interpret how a claim should be paid, or if it shouldn't be paid. And most importantly, if an insurer is dragging their feet or not paying a claim, they can actually argue the point on your behalf. And that's a very critical part of the broking role. For this, their remuneration or income is by way of two things. First and foremost, it's commissions. Commissions are generally paid by the insurance company or the underwriting agency in our case to the broker for placing the business with the company, and fees are generally paid or charged to the OC or the client for services rendered or future services rendered. Just to give you an overview, like I said, this is Insurance 101, so it's not really designed to go in depth, but the whole idea is really there so that you guys can get a feel for why the strata industry, or where the strata industry fits as far as insurance is concerned. I'm double hearing myself, which is a bit hard, but anyway. Look, there's a number of different areas of insurance, such as life and health insurance. The one that concerns the strata industry as such is general insurance. General insurance. General insurance is broken down into three main categories. There's property, liability, and casualty insurance. I won't go into too much detail. I've actually put liability and casualty next to each other, and the reason for that is that there are some risks associated with casualty insurance that actually do fall into liability. But from a viewpoint, there are three different categories. You'll notice some very everyday sorts of things that you insure, such as cars, homes and boats under property insurance. Under liability insurance, rather than going through all of the different bits and pieces, basically liability and casualty insurance is primarily concerned about the risks associated with personal injury and property damage to other persons, and wrongful acts such as defamation and errors and omissions in advice. It also encompasses such things as injuries to insured persons, such as you would find under a volunteer workers' personal accident policy, which is generally part of most strata policies. Now, we'll talk a little bit later on about legislation and the specifics regarding the OC Act. But just to give you a bit of a flavour about policies as far as strata is concerned, the two main covers that are out there, or the two minimum covers I should say, that are required by the strata community are buildings and common property insurance for property damage, and public liability for common property in accordance with the Act, which is for a minimum of $10 million. So you can insure for $20 million or $50 million, you just can't go on. For buildings, as I said, it's the replacement value of the building. So it must actually be the sum insured that you have on your insurance certificate must be able to rebuild the building to its former state of glory as if it was new. So using today's materials, it could be a 100-year-old building, must be able to rebuild it with today's materials, today's knowledge and engineering process, and it must be able to be rebuilt today. So building could look like it's a shabby old place and it's ready to fall apart, but it must be for replacement value. Now, I've been asked to actually talk about also some suggested areas of insurance. All of the covers that are up there on the slide are covers within insurance products. So some of them down the bottom with the asterisks, they are automatic within most strata policies, and you'll find the likes of longitude, SCI, and so on and so forth will all offer those automatically. I really just wanted to talk about, like I said earlier, I really want to give you some takeaway points and some areas that I find issues in as far as the industry is concerned. The four areas of concern that I have are at the very top. So it's floating floorboards and removal of debris under property. It's the office liability component of a possible risk, and the statutory fines and penalties, which are that can be labelled against us. idea of it is that hopefully you'll have some solutions and just some ways to think about it. So first and foremost, floating floors. As OC managers, you're probably aware about what the Act actually does and what it doesn't do. Floating floors are pretty much floors, puncture floors, that are clip-locked like Lego into the substrate bolts and so on. If you turn the building literally upside down, they fall out like blocks. That's as simple as that. For floorboards to be automatically covered under a strata policy without actually covering floating floorboards, they've got to be glued, screwed or nailed into the substrate underneath, whether or not it be beams or the concrete underneath. Now, you'll no doubt know that if you've had claims in this regard, as soon as a water damage claim comes along, or it's a water burst pipe or something like that happens within the property, the clip-lock flooring or floating floorboards generally buckle. They're not held together, they literally shrink and then expand, and your client is adversely affected. Generally, they're fairly cheap to add as far as cover is concerned under owners corporation policies. And I think, as a takeaway point, I'd almost like to see owners corporation managers ask for that as an automatic cover, just so that there's some peace of mind. One of the biggest deals, I suppose, is it does depend on obviously how big your OC is. I mean, if you're managing a 4-block or something like that, yeah, you probably know every single unit owner. You know what's inside there, so you can make a decision, an informed decision on what you can and can't insure. But if you're talking 100 lots or 200 lots or something like that, you're going to have absolutely no idea what's in each unit. So it could be tiles, it could be carpets, it could be parquetry floors, it could be proper floorboards. So it's a thing that I really do think that you should think about. Another area that, look, it's not that I'm critical of, but I think people should think about is removal of debris. Acronym in insurance is ROD, so if you hear that, that's what I mean, removal of debris. It's a pretty boring part of insurance, to tell you the truth, but it's the risks, it's the costs associated with removing debris of damaged and undamaged property, so the property can be rebuilt after an insurance claim. Pretty much the basic example is building burns down, it's got to be levelled, all of the debris and bricks and mortar and everything's got to be taken away so that you can rebuild a building. That is what the removal of debris is. Now, all covers in the marketplace offer a limit for removal of debris. However, I don't believe there's enough emphasis on what I call the unknown, which are areas that can escalate and increase the overall costs and remove the debris, and thus also increase the replacement value of what you're supposed to be insuring for. The unknowns are referred to as such things as toxic materials, such as asbestos. Pretty much with asbestos, you've got to have a particular way in which you remove that. There's got to be specialist involvement. That increases the cost of that component of the insurance. Another unknown is where the property is, and I don't think enough people actually realise this, but to give you an idea of, if a property was to burn down in, say, Chapel Street, you've got to think of things outside of the fact that you've just got to come in and remove the debris. You've probably got to get council involvement, permits, you've got to shut down tram services, you've got to have guards and security people come in and basically guide traffic and so on and so forth. They're all costs that actually escalate the cost of rebuilding and the cost of removal of debris. There are two solutions, I believe. First one is pretty simple, and I'd probably say this is the one that you should think about more often than not, is to get a quantitative surveyor's valuation on your property. I know that the Act says you only have to have one every 5 years, but get one at least anyway, and it doesn't matter how big, small, or whatever it is. Get a quantitative surveyor's valuation, and that should take those risks into consideration. The other is to seek an insurance policy that doesn't restrict removal of debris. Now, there's market policies out there. I suggest you talk to your insurance broker about finding out where those are. Another area, we move along to office bearer's liability. Look, pretty simply put, office bearer's liability is the wrongdoing of alleged committee members of the OC. Now, an example of that might be that the Owners Corporation insures a building for $8 million. Now, they have a valuation that says the building replacement value is $10 million. but they elect not to increase that sum insured. Building burns down, effectively, they are $2 million short of what is required to rebuild that building. Now, there will be unit holders who didn't make the decision not to increase the premium, or the sum insured, and they will be affected adversely by that lack of action. Now, they have a right under office bearer's liability to sue the Owners Corporation Committee for their lack of action, for what is known as their wrongful act or negligence in concerning that. In addition to that, and I've sort of dovetailed this into statutory fines and penalties, is that because the Owners Corporation Act requires the Owners Corporation to have a replacement value for buildings and removal of debris, and they haven't elected to insure for the correct amount, they could be fined by the Victorian State Government as a result of breaching the legislation. Now, statutory fines and penalties pays for that component, the fine and the penalty that's imposed by the breaching of legislation. They're things that I think you should think about as far as covers are concerned, in addition to the norms being building liability, the automatic covers such as volunteer workers, so on and so forth. But those four areas are the ones that I really do think you should think about a little bit more seriously. Now we'll start talking about the areas of legislation. Now, legislation runs everyone's daily grind, unfortunately. Three pieces of legislation run out. The Owners Corporation Act of 2006, the Terrorism Act of 2003, and also the Insurance Contracts Act of 1984. First we'll go into is the Owners Corporation Act, and specifically the requirement for valuations. The OC Act, as I've said in the previous two slides, requires the OC to insure for the full replacement value of buildings and common property, including provision of removal of debris, which is under Section 59. I think that's what it's called, Section 59. I know it's the insurance section, maybe it's insurance, the Section 59 of the insurance division of the Act, but anyway. It also, under Section 55 of that, requires certain properties that fall under the definition of prescribed owners corporations, and I'll let you work out what they are, to have a valuation conducted every 5 years. I believe as a result of the Act not requiring all owners corporations to have valuations, this causes many smaller properties to be underinsured. We've already harped on a moment in the past about lack of action and not insuring for correct amounts. This leaves the owners corporation exposed in two areas. We go back to sum insured's not good enough, office bearer's liability, breaching legislation. So there's a whole array of things that can occur after the fact that if you haven't actually insured for the correct amount. Now, I won't go into specifics about the Act. I think there's an excerpt at the back which is showing what Section 59 says and what Section 65 says. What I will go into is by virtue of making the valuation requirement only applicable to larger owners corporations, it allows smaller owner corporations to insure for values they can afford rather than what is required to rebuild their buildings, which is actually what the Act wants them to do. Now, solutions for this. Whilst I suggest, and I've suggested before, that owners corporations should seek valuations from quantitative surveys, there is another option, and it's probably the easiest option to think about. You're going to get renewals on a regular basis for your clients. All insurers offer what is referred to as a suggested option on their renewals as far as sums insured are concerned. It's basically last year's sum insured plus a percentage increase, which is roughly CPI or indexation orientated. By taking up this option, it will give the OC manager and the Owners Corporation Committee some peace of mind, not a lot, but some peace of mind, that the sums insured are being increased in line with inflationary requirements, rather than doing nothing or not having a valuation at all. Next piece of legislation is the Terrorism Act of 2003. This was basically introduced as a result of the terror acts in the US on September 11, 2001. In short, our federal government brought in legislation that allowed them to collect a premium or a pool of premium to put away in case there was an act of terror on Australian soil. There were previously some gaps in the cover where certain buildings weren't covered. The recent changes, which will take effect from the 1st of July this year, are basically there to eliminate that gap. Now, the basics are, or the gaps that I'm talking to you about, are residential buildings that are valued at $50 million and above weren't previously covered under the Act. There are companies out there that offered some sort of level of cover, but in general, most of the insurers wouldn't have offered any terrorism cover at all. And, the other one is commercial properties, or mixed commercial properties with an aspect of commerciality that's in excess of 20%. Previously, those buildings that had 20% commercial occupation up to, I think it was 50%, weren't covered at all, which basically left them at the mercies of whatever may occur. Now, obviously, we haven't had a terror act in Australia, so it hasn't had to worry us too much at the moment. But the idea of these changes are that they will eliminate those gaps, and you should, because July 1st is just around the corner, you should probably start getting from most of your insurers some information about that and what their intentions are going forward. So keep that in the forefront of your mind. One of the biggest things about that is that those insurers who don't have other options as far as levels of cover outside of their own company and pay into the terror, into the ARPC, which is the pool that takes the money, those companies will probably on charge the terrorism fee to your OCs. Now, in particular, you're going to find that in CBD areas, because in some cases you're talking 30% of premiums. So there may be some very big increases. So leave that as a takeaway point, guys. Just maybe talk to your insurance representatives just to find out a little bit more about it. But should definitely be in the forefront of your mind. Last piece of legislation I just wanted to go through, basically it's the one that I've got to look at every day of the week, which is the Insurance Contracts Act. In particular, clause or section 21, which is the insurer's duty of disclosure. Duty of disclosure is the most important requirement of a client seeking insurance coverage or renewing their policy. This is whether or not it's a strata, a motor, a car, or a business insurance, whatever type of policy. Basically, it's a legal obligation a client has to inform the insurer of anything that materially changes the risk or that might alter the way in which an insurer considers insuring the property. Included at the back of the presentation is an insurance proposal, and it shows you the types of questions that insurers will request details on. However, there are situations, and there's plenty of situations, where proposals aren't part of the submission that's going to the insurance company, so some information may be forgotten. Therefore, knowing your obligation to provide the insurer with as much information as possible is extremely important, and this is called the duty of disclosure. Examples of things that might get missed: defects in property, presence of asbestos, previous claims, recent changes to types of materials that we're seeing out there as far as building materials are concerned, can change the insurer's attitude as to how they insure a property. Such things as aluminium composite panelling. You would have heard of a Lucabond. It's on the outside of La Crosse. Expandable polystyrene or EPS. Break open and escape. Basically, the building is made of that sort of material. They're things that can change an insurer's attitude as to how they want to insure a policy or provide terms. Another important disclosure issue, and I'm seeing this more often than not, is imposed excesses. If you've got a policy with an insurance company and they've got a non-standard excess, so standard excess usually says excess $300 each and every claim, you suddenly see something that says $2,500 for water damage or $2,500 for malicious damage or whatever it might be. They are specific excesses. You have a right and a duty to tell your insurance representative that that is on the current policy. If you don't, look, at the end of the day, the main thing is to remember, I suppose, is that if the duty of disclosure is breached, it may change the way in which the insurer handles a claim. Because usually when there's a breach of duty disclosure, it's found out when there's a claim. It's never, you know, if everything's running fine, it's fantastic. Now, depending on the type of breach, your insurance company may reduce a claim. They may choose to actually do nothing at all. It may not be adverse in any way, shape or form, but they may choose to reduce a claim. And in any extreme cases of fraud or fraudulent misrepresentation, they may decide to deny the claim outright. So it's very important to know your duties there. Last but not least, I'm going to just give you some takeaway points. I'm not going to